Thank you very much for coming. We're all going to stay seated for the sake of the microphones and the recording. I'm Simon Salzedo. Those of you with advanced powers of logic will realise that that implies that I am not Sir Richard Akins. I'm afraid he had a bike accident, nothing terrible, but he's very bruised and was not able to come. So I'm chairing myself as his understudy and also will cover his bit of the talk. So apologies for that. We're going to attempt to summarise for you the new insurance legislation which is coming into force in the next couple of weeks. Mainly the Insurance Act, but also the Third Party Rights Against Insurers Act 2010, all coming into force shortly. The plan is I'm going to talk through parts 2 and 3 of the Insurance Act 2015. Steve Midwinter on my right will then cover parts 4 and 5, and Charlotte Thomas on my left will deal with the Third Party Rights Act and the relevant parts of the Enterprise Act 2016, which have also made some amendments to the Insurance Act. Given the available time, we're going to go through it at a relatively high level, trying to point out where the points of interest are, where the changes in the law are. I think any greater depth would just take too long, or mean we weren't covering everything. So that's the idea. You've got a handout which gives you the sort of plan of what we're going to say. The Insurance Act 2015 is coming into force on the 12th of August this year. It's based on Law Commission work and a draft bill produced by the Law Commission. We've set out what the parts are, and we're basically going through them in order. So part 2 is called Duty of Fair Presentation. It applies to non-consumer contracts. There's already been a change in the law of consumer contracts, as you probably know, in the 2012 Act, sometimes called KIDRA or SIDRA, and also, of course, to variations of non-consumer insurance contracts. Section 3 provides that the insured must make a fair presentation of the risk. That is a term which is familiar to English insurance litigators. It's one which I think I had a look into the cases, and as far as I could see, it was invented in the early 80s, quite possibly by Lord Justice Carr, as a description of the effect of the various common law rules about non-disclosure and so on. But it's now put into statute that what's required is a fair presentation of the risk. And then that's defined as a presentation which makes the required disclosure in a manner which would be reasonably clear and accessible to a prudent insurer, in which every material representation as to a matter of fact is substantially correct, and every material representation as to a matter of expectation or belief is made in good faith. Now, all of that is very close to the existing common law, and indeed the law as codified in the 1906 Marine Insurance Act. The only aspect of that which is arguably new is the phrase that the disclosure has to be made in a manner which is reasonably clear and accessible. And that phrase, clear and accessible, doesn't feature in the law of fair presentation until now. It's referred to in completely different contexts. It, I think, is intended not to make any change in the law, but to reflect the principle, which I think has been developed in the law, that it's not good enough if the crucial piece of information, the really material fact, is hidden away in a great big pile of documents that no reasonable insurer would actually read. So that's always been there, and I think that's what reasonably clear and accessible is intended to repeat. But there's scope for argument about that because it's a phrase which does not feature in insurance decisions up till now. The required disclosure, in line with the existing law, is every material circumstance which the insured knows or ought to know, or sufficient disclosure to put a prudent insurer on notice that it ought to make further inquiries to reveal those material circumstances. Absent, just like, as in the current law, absent inquiry, no disclosure is required of matters that diminish the risk, which the insurer knows or ought to know, or is presumed to know, or which he waives. So that, just like that's the existing law, and that is all reenacted. One thing which is different in the new Act, though, that was all Section 3. Sections 4 and 5 set out in some detail what counts as knowledge, separately for the insurer and the insured. It's not very different to what you'd expect, but it probably is slightly different to the general law. And it's important to know it's there because it'll always need to be referred to. So the insured knows only that which is known to individuals who are either the insured, if it's an individual, part of the insured's senior management, or responsible for the insured's insurance. And that last category, of course, covers brokers and their employees who are actually working on placing this insurance. The phrase part of the insured's senior management, I suspect, is quite significant because it means it doesn't just cover those who are actually involved in the placing or in communicating with the brokers. So in a large company, it may be necessary for inquiry to be sent out to make sure that material facts are gleaned from other members of senior management, which obviously is a phrase that could come in for interpretation. It's specified that an insured is not taken to know confidential information in the hands of his agent, so such as the placing broker, which was acquired through a business relationship with a person who is not the insured and is not going to be covered by this insurance. So the insured is not fixed with the knowledge of his broker that his broker has got through other work for other clients, as long as it's confidential. So that line is clearly drawn, probably not very differently to how it would be drawn by the common law, but it's in statute. And the insured also ought to know, is treated therefore effectively as knowing, whatever should reasonably have been revealed by a reasonable search of information available to the insured. And to some extent, of course, that is a matter of, in a company, making sure you ask senior management, do they know anything material to this insurance? Whether it goes any further, that probably is open to dispute as to what counts as reasonably available, what counts as a reasonable search in all the circumstances of the particular insurance. So that's I think a nice area for potential interest in the future. And then separately, Section 5 tells you what counts as the insurer's knowledge, because of course there's no non-disclosure if the insurer already knows or ought to know. An insurer knows or ought to know that which is known to an individual who's participating on behalf of the insurer in the decision whether to take the risk, i.e. the underwriter, or that which is known to an employee or agent of the insurer who ought reasonably to have passed it on to a person participating in the decision whether to take the risk, i.e. Somebody who works for the insurer, possibly an agent, who ought reasonably to have passed on their knowledge to the underwriter, or knowledge which is held by the insurer and is readily available to an individual participating in the decision whether to take the risk. Now, again, this doesn't sound like a massive departure from the common law of attribution of knowledge to an insurance company, but nor is it a direct enactment of the rather broader way in which the common law might approach attribution. So again, there is the potential for argument about when somebody ought reasonably to have passed information on to the underwriter, or when information is readily available to an underwriter. And obviously the kind of situation in which this might arise is, for example, information might be on the insured's claim file, might be on some other insured's claim file. And in those circumstances, there could be all different facts which might affect whether you would reasonably expect the information to be passed on to the underwriter. So I think there's scope for, again, unpacking those new statutory provisions, all of which could be of interest. An insurer, and then I think the insurer is presumed to know matters which are common knowledge, matters which are common knowledge, and things which an insurer in his particular business would be expected to know, and that I think does reflect the common law as long established. There's then a couple of provisions in Section 6 which apply to both insurer and insured, Knowledge includes blind eye knowledge, so knowledge that you would have had if you hadn't deliberately closed your eyes to receiving it. And also specifically, this part does not abrogate the Hampshire land principle in two specific respects, which are where the insured's agent, his broker, is perpetrating a fraud on the insured, then his knowledge is not attributed to the insured. And similarly, where the underwriter is perpetrating a fraud on the insurer, then his knowledge is not attributed. So essentially, the Hampshire land principle is preserved in those two cases. We then start coming on to remedies, which is where there are one or two dramatic changes. First of all, actual inducement is preserved in the terms it was decided by the House of Lords in Pan Atlantic and Pine Top, which is now enacted. So that's a new codification of the common law. And if actual inducement is shown, that's to say the insurer wouldn't have entered into the insurance or would have done it on different terms if there had been a fair presentation. Once it's shown, then the remedies are set out in Schedule 1. And the remedies depend on the nature of the breach. If the breach was deliberate or reckless, this is the breach of the duty of fair presentation. If it was deliberate or reckless, the insurer can avoid the contract and refuse all claims and not repay any premium. Not that dissimilar to where you'd be now if you had a fraudulent misrepresentation or the like. If, but for the breach, the insurer would not have entered into the contract at all, then the insurer may avoid the contract but return the premium, which again is similar to where you'd be now if you had a non-disclosure with that consequence about any actual inducement. But where it's different is if the insurer doesn't show that he would have not entered into the contract at all, but instead only shows that the contract would have been on different terms, then the insurer can elect to treat the contract as if it was on those different terms, which will give trial judges, I think, a great deal of interest and lawyers a great deal of fun in coming up with what the terms would have been that the insurer would have offered and the insured would have accepted. Obviously, the insured is in some difficulty because if the insured says, I wouldn't have accepted those terms, then you could then go back in the position where that means the insurer wouldn't have entered into it at all. But presumably, you have to imagine and you have to have evidence about what the negotiation would have been if the insurer had said, well, if you told me X, if you tell me X, I will have, I want term Y. And then the insured might have said, well, I don't like term Y, what about term Z? And presumably we have to go through all that potentially at trial before the insurer can decide whether he elects to treat the insurance if they're on those terms. So that's quite an interesting one. And then the provision, which is of fun for those of us who like a bit of maths, if the insurer shows he would have charged a higher premium for the insurance if fair presentation had been made, then the claim is reduced in the same proportion as that the premium bore to what should have been the premium. So if you can show, as an insurer, that the premium would have been, say, well, I'll be careful with maths, it's much easier if you do it with just a half. If the premium would have been double, so the true premium is half what it should have been, he can cut the claims in half. So that's enjoyable mathematically, but of course, again, it means that there'll be a premium on evidence about exactly what the premium would have been, and and presumably there'll be evidence from both sides about what the negotiation would have been. So that will also give rise to fun for litigators. That's the end of my section. I'm now going to be Sir Richard Aiken's understudy and tell you about part 3. So imagine I'm speaking in a different voice, and then that will help you stay awake. But I won't do an impression. So part 3 is about warranties, and probably everyone in this audience is well familiar with the general law that an insurance warranty is a strict term which, if it's breached, discharges the insurer from liability under the contract automatically forevermore. Now, this short part of the Act changes a number of things. First of all, Section 9 abolishes basis clauses. So what it says is that representations made by the insured are not capable of being converted into a warranty by a provision in the insurance contract. This has already been done in consumer contracts, now done for non-consumer contracts too. It's a slightly odd provision because, of course, you could always convert a representation into a warranty by spelling it out in the contract. And that's okay. The Act doesn't stop you doing that. But what it does stop you doing is saying anything that you've represented to me, I will treat as a warranty. That is not effective by Section 9. So that's an important change. One of the most dramatic provisions of the Act, which I'm sure was fun for the draftsman, is Section 10.1, which says any rule of law that a breach of warranty, express or implied, in a contract of insurance results in the discharge of the insurance liability under the contract is abolished. Very dramatic. However, the overall effect is less dramatic because the next subsection provides for a suspensive form of the rule. So an insurer now has no liability under a contract of insurance in respect of any loss occurring or attributable to something happening after a warranty has been breached but before it has been remedied. So warranties have now changed. They will change when the Act comes into force next month. Warranties will change from discharging liability to suspending liability until the breach is remedied. And we'll come to a bit more about how that works in a moment. So there are a number of then explanations as to how that works. The first 3 points effectively reflect the existing law in the Marine Insurance Act as to when a warranty doesn't work for the insurer. A warranty is not effective for the insurer if, because of a change of circumstances, the warranty ceases to be applicable in the circumstances of the contract, and so that's in the Marine Insurance Act and that carries on. Compliance is rendered unlawful by subsequent law, same words as the Marine Insurance Act, or the insurer waives the breach of warranty. So all of that is actually just reenacting what was in the 1906 Act. The new provisions, though, are about the remedying a breach. If the warranty is that an act will be done by a certain time or something will happen by a certain time, and the breach of warranty is it didn't happen by that time, then the breach is remedied if the risk to which the warranty relates later becomes essentially the same as that originally contemplated by the parties. That wording, I'm sure, will generate some litigation. The essential point is, if it's one of those things which, while it isn't done, it possibly increases the risk, and the insurer is entitled to have it done, but once it's done, then everything's back to normal. If it's that kind of warranty, then once it is done, the breach is remedied, and the warranty ceases to have any. The breach ceases to have any effect. But if it's another kind of warranty where it matters whether it was done on time or not, and the lateness increases the risk, then you can't remedy it. So which of those it is, I suspect, will be open for dispute in some cases. If it's any other kind of breach of warranty, then it's remedied when the insured ceases to be in breach of it. So you can cease to be in breach of warranty and the breach ceases. And that then takes us to the last section in my parts, which is also probably the most new, the most complex, and the most certain to give rise to dispute, which is Section 11. Section 11 applies to terms which, compliance with which would tend to reduce the risk of loss of a particular kind or in a particular place or at a particular time. So it's terms which tend to reduce risks of particular types. That includes warranties. Section 11 is clear that it includes warranties, but it is not limited to warranties. And it doesn't include terms which define the risk as a whole. So the first thing you have to look at is this a term which tends to reduce risks of particular types, places or times? If so, is it a term that defines the risk as a whole? And I'm sure that there's room for dispute about whether a term falls into that category. If it is one of those terms, and if it's not complied with, then the insurer may not rely on that non-compliance to exclude, limit or discharge liability if the insured shows that non-compliance with the term could not have increased the risk of the loss which actually occurred in the circumstances in which it occurred. Now, the important thing to note about that is it's not intending to create a causal relationship between the breach and the loss. It's not saying that the insured has to show that the loss wasn't caused by the breach. It's wider than that. It's more objective than that. According to the government's explanatory notes, what it's actually saying is you have to look at the objective purpose of the term. What kind of risk could it have reduced? And if the loss which actually occurred is within that class, then the breach is one the insurer can rely on. But if the insured can show that the type of risk which this provision was there to reduce is not the type of risk which eventuated, then the provision is not to be relied on by insurers. So that is a fantastically complicated provision. I think many people think it's fantastically badly drafted. So as far as litigators are concerned, that is one very much to focus on. That said, of course, the courts may well do their best to make some sense of it, to create some rules of thumb which will create a bit more certainty in the future. But for the time being, that one in particular is probably a good one for us to focus on. And I'll hand over to Stephen to cover the rest of the Act.
Yeah. I'm talking about Section 12, Part 4, fraudulent claims. The good news is that Section 12 essentially codifies the existing common law. I could leave it there. I'm sure you all know what the existing common law is, but you might feel short-souled. So I'll carry on and tell you what the common law is that's been codified in Section 12. The Law Commission paper identified the problem with the common law on fraudulent claims as being that it's not clear what the remedy is in the event of a fraudulent claim being made. The Law Commission was concerned that it was arguable that the making of a fraudulent claim could lead to avoidance of the policy, and that was not right, and that what a fraudulent claim should lead to is forfeiture of the claim and termination of the policy, but not the ability to recover past claims that have been paid, rights that have been accrued prior to the fraud. The Supreme Court, in the Salzedo case, which I'm going to come on to in a moment, thought that that was clear, that that was what the common law was anyway. And when counsel for the respondent in the Salzedo appeal drew the court's attention to the Law Commission report, they were rather dismissive, suggesting that perhaps the Law Commission hadn't noticed Lord Justice Mance's decisions in the Aegeon and the Gottlieb cases, and that the Law Commission's report may have been a hangover from an earlier draft that ought to have been updated. We needn't get into that. The position was, if one reads the Aegeon and the Gottlieb cases, that Lord Justice Mance, as he then was, had developed the law on this. In the Gottlieb case, what had happened was that there was a policy of buildings insurance, and 4 claims were made over the course of a year. 4 separate claims, 4 separate events. Claims 1 and 2 were perfectly honest and genuine claims, and they were paid. Claims 3 and 4 were both affected by fraud. In claim 3, they had claimed that they had to stay at a hotel while repairs were carried out on the building, and that wasn't true. There had in fact been an insured loss, but they lied about that. And on claim 4, again, there was an insured loss, but they submitted a fraudulent invoice from an electrician in relation to £1,200 worth of electrical works that in fact were never carried out. Both those claims were affected by those frauds, and what the Court of Appeal held was that the result of those frauds was that claims 3 and 4 could be rejected in their entirety and the policy terminated at the date of the first fraudulent act, but that claims 1 and 2 could not be recovered by the insurers because they had been completed before any fraud occurred. And that is essentially what Section 12 now says in statute. There is one point of helpful clarification in Section 12, which is in Section 12.4. It clarifies that the distinction between a claim which has accrued and one which hasn't accrued occurs at the date when there's a relevant event, and it defines the relevant event as being the thing that gives rise to liability under the insurance policy. So provided the thing that gives rise to liability under the insurance policy has happened before any fraud occurs and relates to a separate claim from the one in which the fraud occurs, you can still recover in respect of that accrued separate claim. So to take an example that might arise, an employer's liability policy offering cover for asbestos-related claims, all of the events in relation to mesothelioma claims happened many years ago on the basis that the policy covers injuries contracted when the fibres are inhaled. If the employer fraudulently inflates a claim in relation to employee A, they'll forfeit that claim and the policy may be terminated, but that won't affect their ability to recover in respect of a claim in relation to employee B, where the insurer's liability will have accrued at the time the fibres were inhaled many years ago, and so the relevant event has occurred before any fraud, and the claim is separate, they can still recover. That's the idea. So the Law Commission may perhaps have overstated the lack of clarity in relation to the remedy because Lord Justice Mance had been developing the law in this way. Some of the textbooks suggested that on the basis of the Star C, the avoidance argument was still open, possibly to an insurer, and Section 12 helpfully clarifies that that's not the case. You can't avoid for a fraudulent claim. What you can do is say the claim is forfeit, any interim payments in relation to that claim can be recovered, but separate claims that accrued prior to the date of any fraudulent act, the insured can still pursue. The Act deliberately doesn't define what a fraudulent claim is. That's actually the most interesting and fraught question, and the Law Commission deliberately duck it. It's quite clear from the Law Commission's consultation paper that they were not drawing any distinction between the fraudulent claim cases and the fraudulent device cases. The Law Commission thought that the same policy applied to both sorts of case, and that in all sorts of case, those should be treated as fraudulent claims, and the forfeiture rule applied to them. What do I mean by the distinction between fraudulent claims and fraudulent devices? A fraudulent claim is when an insured makes a claim that they don't believe to be a genuine claim at all. So the ship never sank, the fire never happened. A fraudulent device is when an insured makes a claim which they believe to be a genuine claim, but they tell some sort of lie to smooth things over. And the best example of that is the Salzedo case, which I'll come on to now. The logic of the fraudulent device doctrine is that it doesn't actually matter whether or not the claim is genuine at all. All that matters is whether the insured is acting honestly. So if an insured says that there is a claim when he doesn't have any proper basis for believing that to be true, so he's recklessly saying that there is a claim, it doesn't matter that it later turns out that there was in fact a genuine claim. He has made a fraudulent claim and the policy can be terminated as at the date when he makes that claim. The Salzedo case is the clearest illustration of how this can work harshly on an insured. The facts there, as many of you may know, are that a ship was lost and there was a £3.2 million genuine insurance claim that was covered, as it turned out, under the insurance policy. The way the loss occurred was that the ship began taking in water for very complicated reasons. Some water was left in something which then froze and cracked, and water started coming in at the bow. And it was not clear why an alarm hadn't triggered the crew into doing something about this, what must have been a fairly slow leak of water into the ship. The owner suspected that the answer was that the alarm had gone off, but the crew had ignored it because it went off quite a lot. His fraud was to say to the insurers that that was in fact the case, when he hadn't checked with the crew whether or not that was the case. He asserted it as a fact. He didn't have a basis for that. He then later checked the position with the master, who thought that was probably right. But that was too late. The fraud had occurred because he had said something as fact which he didn't know was right. And there was some evidence that he'd done that because he was concerned that if the answer was that the alarm hadn't gone off, the insurers would say that the ship was not seaworthy or that proper precautions hadn't been taken and deny the claim. So he made a helpful assumption to himself that what would happen was that the alarm had gone off and the crew hadn't checked it because he wanted to head off inquiry. At first instance, Mr. Justice Popplewell, who had been the counsel in one of the cases establishing the fraudulent devices doctrine successfully before Lord Justice Mance, he held that that was a fraudulent device. It didn't matter that there was a genuine claim for 3.2 million. the claim was forfeit under Lord Justice Mance's formulation of the law in the Aegeon. But he expressed very clear reluctance in reaching that conclusion and thought it was unjust. The case went to the Court of Appeal. The Court of Appeal upheld that decision with a bit less reluctance. Lord Justice Christopher Clark noted that it worked very harshly in that case, but that the policy reason behind the fraudulent devices doctrine was to discourage insureds from having a go, putting forward better facts than they really were, safe in the knowledge that if the claim was genuine, they'd recover anyway, and that policy justification meant that, though this was a harsh case, it was right that the claim was forfeit. It went to the Supreme Court. The hearing was a few weeks ago. I watched the hearing on the Supreme Court website in preparation for this lecture to try and gauge the reactions of the court. Lord Mance was on the panel, and perhaps unsurprisingly, it looks as though he thinks he was right in the Aegeon and the Gottlieb case to say that in fraudulent device cases, the claim is forfeit. He doesn't see any problem with that at all. And I think Lord Hughes was with him, judging by the questions that he was asking of counsel. Lord Toulson was also on the panel. Interestingly, he had been the judge at first instance who was reversed by Lord Justice Mance in the Aegeon. He had thought that fraudulent device cases were different from fraudulent claim cases. It's not clear which way he was going in this case. Lord Sumption was also on the panel, and it was pretty clear that he didn't think very much of the contention that a representation which in fact was irrelevant because there was a genuine claim should lead to a loss of the policy. Which way he will go, a loss of the claim rather, which way he will go eventually, I don't know. There are some pretty ill-tempered exchanges between him and Lord Mance, not necessarily unusual. I think if you go about an hour and 20 minutes into the afternoon of day one, Lord Mance slaps Lord Sumption down quite brutally when Lord Sumption suggests that it's odd that there is a distinction between the situation pre-contractually when there is fraud and a situation where a fraudulent claim is made. And Lord Mance points out that if a dishonest statement was made pre-contractually, even if not material to the risk, there's no way that the underwriter would in fact go on to write the business, and suggest that perhaps Lord Sumption isn't being very realistic. The fifth member of the panel was Lord Clark, who again, perhaps characteristically, is rather Delphic. He made a few sarcastic comments to both sides' counsel, which didn't really suggest which way he was going. So it's hard to tell which way that's going to go in the Supreme Court. What counsel for the respondent there and Lord Mance made very clear was this policy reason is the reason behind this unusual rule. Of course, ordinarily, if you commit fraud in a claim, it doesn't mean that you forfeit the claim. If I say you've breached a contract with me and caused me £10 million of loss, in fact, you only caused me £5 million of loss, I can still recover from the court the £5 million. I don't forfeit the claim because of my fraudulent letter before claim to you. This is a special rule for insurance contracts, and if it's justified on this basis that there's something particular about insurance contracts, which means that you must dissuade insureds from having a go at telling lies to make their lives easier, safe in the knowledge that if the lie is found out, they can still recover. And the Law Commission, in their consultation paper, treat that policy justification as being very serious, and they think that the Salzedo case in the Court of Appeal is probably right. The only question is whether the particular misrepresentation in that case was material or not, the Law Commission would suggest. So that's Section 12. It preserves the common law position. Whether you've got a fraudulent claim or a fraudulent device, the result will be that you forfeit the claim, you can terminate the policy as an insurer, but it doesn't affect pre-existing accrued rights. Section 13 just relates then to composite or group insurances and makes clear again what the common law would say anyway, that a fraud by one insured doesn't affect the position of other insureds under a composite or a group insurance policy. Then just very briefly on Part 5 of the Act, Section 14 provides that a breach of the utmost duty of utmost good faith set out in Section 17 of the Marine Insurance Act no longer gives rise to a right to avoid. That ties in with the provisions that Simon was talking about. The remedies for a breach of the duty of disclosure are now set out in the Act, and an insurer can no longer argue that there's some broader right to avoid for a breach of the duty of utmost good faith. That is gone. Sections 15 to 17 deal with contracting out of the statute, not just Part 4 and Part 5, but the whole statute. Section 15 provides there's to be no contracting out in consumer insurance, Section 16 provides that you can't contract out of Section 9, so you definitely can't get back in basis clauses on any basis. They're apparently a particular evil. But you can contract out of anything else, provided your contracting out meets the standard of transparency, which is defined in Section 17. What you need to do is show that the contracting out clause is drawn sufficiently to the attention of the insured, or that the insured actually knew about it, whether it was drawn to their attention sufficiently or not. Quite what that will mean, there are obviously parallels with cases under the Unfair Contract Terms Act. If you're doing something particularly draconian, you may need your big red hand pointing to it. But the Act specifically makes relevant the relationship between the insurer and the insured. So if you have a very sophisticated insured, it may well be the case that they are expected to read their insurance policy properly, and you can contract out of any of this if you really want to. And what one does see in relation to fraudulent claims in particular are particular provisions which say that a policy is void in the event of any fraudulent claim being made, notwithstanding the common law. And so it may well be that those provisions continue to exist and they will continue to be valid, provided they are drawn sufficiently to the assured's attention. So that's all I had to say about that.
Thanks very much, Stephen. And Charlotte will now tell us about the Third-Party Rights Against Insurers Act.
So I'm dealing with two enactments, actually, the Third Parties Rights Against Insurance Act and the Enterprise Act 2002. The story of both enactments is that broadly everyone thinks they're quite a good idea, and they've taken a confusingly long time to make their way to the statute books. This is particularly so in the case of the Third Party Rights Against Insurers Act, which has been really painfully slow after being proposed by the Law Commission in 2001. The government said it was a good idea in 2002. It's finally on the statute books and being brought into force in August 2016, along with the Insurance Act 2015. This audience will, of course, be familiar with the problems that gave rise to the need to the Act, especially since we've had 6 years to consider it. But broadly, it addresses the issues which were created by the 1930 Third Party Rights Against Insurers Act. In particular, the issue that while the insured still needs to establish liability while the third party still needs to establish liability on the part of the insured, the Third Party Rights Against Insurers Act 2010 now makes it possible for the third party to proceed directly against the insurer, and that's possible because of the device in Section 2 of the Act, which makes it possible for the third party to establish liability by means of a declaration in a claim directly against the insurer. There's therefore no need to drag the possibly insolvent and dissolved insured out of its dissolution grave in order to establish liability against them in court. The other very welcome development that's been brought by the 2010 Act is the improvement in the position of the third party regarding the information that it's able to obtain about the claim before it brings it. So the courts had got on with things while government was considering the Law Commission proposals. So we had the Law Commission report in 2001 saying it would really be good to have some new rules about this. And at the time that report was written, the position at common law with regard to the right of a third party to information had been very bad indeed. They had to actually establish liability on the part of the insured before they could say that they had a right to obtain information about the insurance policy. But the Court of Appeal had rather markedly improved the position in 2004 by saying that's not right. It's actually as soon as the insured becomes insolvent. So matters had improved, but nonetheless, there was still not sufficient detail about the type of information that might be accessible to the third party. And the 2010 Act now gives, by Section 1 and Schedule 1, an improved and clarified right to obtain information about the insurance position of the insured before it has to make a decision about whether to proceed with a possibly expensive but useless claim. The other interesting development that has been brought about by the 2010 Act is the provisions in Section 9 of the Act, which provide that insurers are no longer allowed to rely upon certain conditions as against third parties. For example, a condition requiring an insured to provide information and assistance where the insured is dissolved or dead and so obviously couldn't have done it, is not something that the insurer is able to rely upon as against the third party. Likewise, a condition requiring the insured to pay out first and then recover under the policy, which of course would render nugatory the development that's been created by the 2010 Act, allowing the third party to proceed directly against the insurer, is no longer a condition upon which an insurer can rely as against a third party. In other cases, the third party itself will be allowed to satisfy certain conditions. So if there's a condition precedent to the claim that notification of the claim is required, that's something that the third party can do itself. So all very sensible. The delay, as this audience may know, has been due to the fact that the 2010 Act, as originally enacted, failed to take account of changes in insurance insolvency law, and in particular the definition of relevant person under the Act. The amendment to fix it was quite obvious, but it didn't become possible, apparently, to obtain parliamentary time to do so until the 2015 Act was considered by Parliament. And I won't bore you by explaining exactly the redefinition that has happened, but in short, a power was created to amend the Third Parties' Rights Against Insurers Act. It was duly exercised in regulations, and now, in essence, a relevant person is broadly people who have not only become insolvent, but also who are in anticipation of becoming insolvent. So it now encompasses people who have entered into voluntary arrangements or schemes of arrangements with their creditors. So the effect of the Act really is to make it procedurally much easier for third parties to proceed against insurers. But it will also have substantive effects, in particular in relation to Section 9. We're invoking Lord Mance's name a lot in vain in this conference, but I was entertained to see his comments when he was giving evidence to the House of Lords on the bill when it was being considered in 2010. He expressed the view that it could be hoped with some degree of assurance that the 2010 Act would have a reasonably case-free future, but then immediately qualified that by saying any lawyer who predicts the future course of litigation would be most unwise. Of course, in some respects, that's what we're attempting to do here by drawing your attention to provisions that may be of interest or the subject of litigation. So we may also wish that we had heeded his warning. And just to note another case in which Lord Mance considered an insurance case in the Supreme Court, which is footnoted in my note, International Energy Group and Zurich Insurance. That was a case about long-tail mesothelioma claims and the problems created for insurers by the Fairchild line of cases. It was another case, in fact, where Lord Sumption and Lord Mance clashed considerably in relation in particular to the insurer's right of recoupment or contribution against the insured, where the insurers had to pay out in these circumstances. I was Lord Sumption's judicial assistant at the time this case was heard, so you'll forgive me for not being quite as frank as Stephen is about what was said during that case, but Lord Mance, having decided that there ought to be such a right of contribution, but that it arose in equity and not under the contract, had cause to consider the position under the 1930 Act and the 2010 Act. And in fact, the conclusion that he reaches, that the right in equity falls outside the contract of insurance and so wouldn't give rise to a right of set-off on the part of the insurer against the third party, is the same position under the 1930 Act and the 2010 Act. So he hasn't undermined his earlier prediction that the 2010 Act wouldn't give rise to much litigation, but it's just an example of some of the complexity that may arise in this particular context, and I'm sure we'll find some things to argue about, in particular, as I say, under Section 9 and in relation to the procedural problems created when the insured is taken out of proceedings, and issues such as rights of contribution may arise that insurers will have to pay attention to and make sure, for example, that they obtain proper assignments of any claims that third parties may have. The next enactment, which didn't take quite so long to get onto the statute books, but nonetheless has been a little dilatory, is the Enterprise Act 2016, Part 5, which deals with late payment of insurance claims. So the law commissions, the English and Scottish law commissions that wrote the report leading to the Insurance Act 2015, recommended there in no uncertain terms that it was time to create a right to damages in the event of late payment of insurance claims. But that was not taken up in the Insurance Act 2015. But it will, however, be brought into force by the Enterprise Act 2016, which amends the Insurance Act to that effect with effect from May 2017. So we have a while to wait, but it's on its way. In essence, the issue here is that English courts have long exempted insurance contracts from the usual rule that a victim of a breach of contract may claim damages for the loss suffered because the other party fails to meet its contractual obligations, based on the legal fiction that the duty of an insurer is to hold the insured harmless, so that in this theory at least, what an insurance company is actually doing is paying damages rather than paying a debt. Of course, it's perhaps unfair to say that the position is that anomalous, because it's only in fairly recent years that the courts have conclusively recognised both that a claimant who has suffered damages owing to their own impecuniosity, and that a claimant who wishes to claim damages arising out of non-payment of a sum of money is able to claim damages as a result of that. So the former was the former was Lagdon and O'Connor in 2003 in the House of Lords, and then the latter was Sempra-Metal 2007, also in the House of Lords. So it's only in relatively recent years that the true anomalous position of this has come to light. The Law Commission, in its report, refers to the case of Sprung and Royal Insurance to explain the difficulties that can arise if a valid claim is delayed. The facts there were a Mr. Sprung who owned a small family business, and he bought insurance to protect his factory against theft and sudden and unforeseen damage. Unfortunately, his premises were targeted by vandals and his factory was destroyed. His claim to his insurer was rejected on the ground that no theft had occurred, and the policies did not provide cover for willful damage. Years later, the insurers abandoned that defence, and Mr. Sprung was awarded an indemnity for his lost plant and machinery, plus interest and costs. But of course, in the meantime, poor Mr. Sprung had gone out of business, and he said he'd lost an additional £75,000. But that simply couldn't be recovered. If the insurance company had paid up more quickly, his business might not have gone under, but that wasn't an option that was available to the judge, and the judge called for the reform in the law, which is finally going to come into force in 2017. So what's going to happen? We're going to have a new Section 13A inserted into the Insurance Act 2015, which will insert an implied term into all insurance contracts, provided that insurers and reinsurers must pay sums due within a reasonable time. It is possible to contract out of it in the case of commercial parties, subject to the transparency provisions, of course, that Stephen's just talked about, and subject to the rule that reckless and deliberate breaches of the term by the insurer can't be contracted out of, so they can't get out of it that easily. And breach of the term, of course, entitles the insured to damages. Not wanting to... So what one avenue for litigation almost certainly will be what on earth is reasonable. As ever, what is reasonable depends on all the relevant circumstances. The Act gives us some guidance for what those might be: type of insurance, size and complexity of the claim, compliance with relevant statutory rules, and factors outside the insurer's control. But how each of those will apply in each individual case will no doubt give us all some cause to ponder. There's also specific provision regarding what happens if an insurer does have reasonable grounds for disputing the claim and wants to delay payment while it advances that defence. There's no guidance, again, about what amounts to reasonable grounds. One might look to the rules on strikeout in CPR Rule 342, but it may be that courts will impose a slightly higher standard on insurers than that, given that the sanction of strikeout may make it appropriate to have a lower standard. Some relief is given to insurers, contrary to what the Law Commission had recommended, in that the limitation period will be only 1 year from the date the payment is actually made, as opposed to 6 years from the date of breach, which is what the Law Commission had recommended. But I suppose, of course, that's only relief if the insurer does actually end up paying up eventually. If they really do take their time, then that will have the effect of extending the limitation period quite dramatically. So I'm assuming that insurers will take advantage of that by paying up, which must be the incentive that was intended to be created. The obvious issues that might be created by this are in particular arise where there are multiple insurers or reinsurers. So either we have a layered policy or we have multiple reinsurers, and the primary insurer decides to delay payment. The circumstances in which reinsurers will be affected either by having to follow settlements or because their own obligation to pay promptly has been affected are likely to be particularly complex, and we'll have to pay attention to that in drafting the contracts themselves. Likewise, insurers will need to take a look at their processes for assessing and settling claims to avoid breaching this implied term. And of course, any damages will be limited by the principle of remoteness, but insurers are likely to be taken to have some knowledge of their insured's businesses and may wish to be in closer contact with their insurers when a claim is made in order to determine what their damages exposure is. So again, more food for thought and more consideration in particular for drafting contracts from May 2017 to cover off some of these issues.
Thanks very much, Charlotte. If people want to ask questions in public session, please do. But I think certainly I expect the three of us will be more than happy to talk shop over a drink if that's your preference instead, particularly since it looks as if it's still reasonably clement outside. So does anybody want to ask any questions or have a discussion in the full session? No, well,
You gave a fairly clear indication that that's really what you wanted.
not at all. It's an entirely open choice. Well, in that case, thank you very much for your kind attention, and we'll adjourn for a drink outside.